Hello friends, today we are going to discuss parliamentary privileges under the Constitution of India. In this module, we are going to discuss the meaning of parliamentary privileges, how they are going to be defined as per Indian Constitution, which is really based upon the British concept of parliamentary privileges. Why do we need, what is the importance and significance of these parliamentary privileges, how these parliamentary privileges got evolved and entrenched in our Constitution, what exactly are the constitutional provisions dealing with parliamentary privileges, and simultaneously, as we all have fundamental rights given under Part 3 of Indian Constitution, what is the relationship between these fundamental rights and parliamentary privileges given under Articles 105 and 194 of Indian Constitution. And whenever there is a tussle between judiciary and legislature, especially on the question of parliamentary privileges, the extent of parliamentary privileges, how these are going to be sorted out, all these details we are going to discuss in this module on parliamentary privileges. As you all know, modern governments run on the basis of harmonious and coordinated efforts of legislature, executive and judiciary. This is called separation of powers. Legislature is there for lawmaking, executive is there to implement the laws or to execute the laws, and judiciary is there for interpretation of laws and also for administration of justice. But these powers are not unfettered, unlimited and unrestrained. These powers are to be exercised within the constitutional limits provided as per the constitutional provisions given in Indian Constitution. The Government of India works at central as well as state level. The legislature is known as Parliament, which constitutes Lok Sabha and Rajya Sabha. Lok Sabha is House of People and Rajya Sabha is Council of States. And at state level, we have legislative assemblies and legislative councils, Vidhan Sabha and Vidhan Parishad. Similarly, at the executive level, we have Union Executive and State Executive. At the apex level, we have Supreme Court of India and High Courts in the states, and we have lower courts throughout India at the lower level. The legislature has been accorded a preeminent position in our Constitution. Apart from lawmaking function, Parliament performs many other functions, like Parliament holds accountable the executive to the House of People, that is Lok Sabha. Parliament holds nation's purse, and also Parliament is having power to amend the Constitution whenever it is necessary. Therefore, we can know that Parliament is holding a very important position to do all these and various other functions, but for that they need parliamentary privileges. Now, what do we mean by parliamentary privileges? Parliamentary privileges is a kind of legal immunity which is accorded to the members of Parliament while they are within the House and conducting proceedings of the House. As Sir S. Erskine May defines parliamentary privilege as the sum of peculiar rights enjoyed by each House collectively as a constituent part of the High Court of Parliament and by members of each House individually, without which they could not discharge their functions and which exceed those possessed by other bodies or individuals. According to him, privilege, though a part of law of the land, is to a certain extent an exemption from the general law. For him, it is a tool for collective discharge of important legislative functions. As per Oxford Dictionary, the term privilege refers to the special right, advantage or immunity to the particular person. It is a special benefit or honor. According to Dicey, nothing is harder to define than the extent of the indefinite powers or rights possessed by either House of Parliament under the head of privilege or law and custom of Parliament. With regard to need, importance and significance of parliamentary privileges, Sir Erskine May says, the distinctive mark of a privilege is its insulary character. The privilege of Parliament are rights which are absolutely necessary for the due execution of its powers. They are enjoyed by individual members because the House cannot perform its functions without unimpeded use of services of its members, and by each House for the protection of its members and the vindication of its own authority and dignity. Therefore, parliamentary privileges and immunities are founded upon the necessity for the efficient discharge of legislative functions. In Parliamentary Privilege First Report, Lord Nicholas in 1999 observed that without this protection, members would be handicapped in performing their parliamentary duties, and the authority of Parliament itself in confronting the executive and as a forum for expressing the anxieties of citizens would be correspondingly diminished. Now we are going to discuss regarding evolution of parliamentary privileges in India. It is true that essentially the parliamentary privileges are originated in England, but in ancient India also we find mention with regard to parliamentary privileges in all the Vedas. We find mention of Smriti and Sabhas, which were nothing else but coordinating parliamentary privileges in ancient India. In Buddhist period, during assembly deliberations also, members could not disobey the assemblies, and if they are disobeying, there can be action taken against them by giving them an opportunity of hearing. A kind of rudimentary as well as developed parliamentary privileges we find in many literatures belonging to India. In 1600, when the Britishers came to India, they came initially as traders, but later on the British Parliament started intervening in the affairs of the company and started regulating their affairs with the help of Regulating Act of 1773, which was followed later on in 1784 with the help of a new Regulating Act. Later on, there were Charter Acts of 1833, 1853, 1854, 1861, 1892 and 1909 in different years regulating the affairs of the company and incorporating different times parliamentary privileges into India. During 1950 till 1950, we find a remarkable growth with regard to parliamentary privileges. With the help of the Government of India Act 1919, the legislative and parliamentary privileges were incorporated, and later on with the help of Government of India Act 1935, we can see there is the wider scope of parliamentary privileges extended to Indian parliamentarians. Meanwhile, in 1925, with the help of Legislative Members Exemption Act, two kinds of parliamentary privileges were recorded. One, that is exemption from jury services, and second, freedom from arrest. Ultimately, with the enactment of India Independence Act in 1947, Indian Dominion was granted with sovereign legislative powers. Freedom of speech has been provided under Article 105 clauses 1 and 2, and similarly under Articles 194 clauses 1 and 2. The very essence of the parliamentary democracy is free, open and unrestricted exchange of opinions inside the Houses of Parliament and state legislatures. Members are freely giving their views within the houses, and they are not feared that they will be held responsible for any offences such as defamation, etc. Apart from freedom of speech, words spoken, they are also going to be not held responsible for any vote given inside the Houses of Parliament or committees thereof. They are going to be free within the Houses of Parliament, and there would be no civil or criminal liability imposed upon them as per the clauses 1 and 2 of Articles 105 and 194. This immunity, which has been provided under these constitutional provisions, is not limited for the words spoken, but also for the other acts transacted inside the Houses of Parliament, such as notices of motions, answering the question answer sessions, passing the resolutions, etc. Article 105 clause 1 provides, subject to the provisions of this constitution and the rules and standing orders regulating the procedure of Parliament, there shall be freedom of speech in the Parliament. Clause 2 provides, no member of Parliament shall be liable to any proceedings in any court in respect of anything said or any vote given by him in the Parliament or any committee thereof, and no person shall be so liable in respect of publication by or under the authority of either House of Parliament or any report, paper, votes or proceedings. These powers, privileges and immunities which are given under clauses 1 and 2, they are going to be decided by a law made by Parliament from time to time. Other persons, ministers or Attorney General, they can take part during the proceedings of the House when they are otherwise not members of the Parliament, as provided under Article 88 of the Constitution of India. Article 194 provides similar provisions with regard to immunities, powers and privileges of state legislatures, which we have studied under Article 105.